I want to again welcome all of you who are joining Howard, Marsee, and myself today in another one of our ADR webinar programs that are part of this series we co-present and co-sponsored with the University of Florida Levin College of Law Institute for Dispute Resolution. Upchurch Watson White Max and the Institute for Dispute Resolution are proud to co-sponsor today's program about crafting the effective mediation summary. A workshop. And I'm joined today by Howard Marsee, who is up in the Orlando area. We're doing this all remotely. Howard and I are joined silently by Kathy Klasny, our firm's media manager, who's up in Volusia County, and I'm sitting down in Palm Beach County. So hopefully technology allows the three of us to cooperate in presenting this to everybody today. So Howard, would you like to tell those who are joining us today a little bit about yourself?
Well, I am a mediator, arbitrator, and a special magistrate. I was a practicing attorney from 1971 to 2003. Trial practice toward the end was heavily medical malpractice. Became certified as a mediator in 1996, became a full-time mediator in 2003, and have been with Upchurch Watson White and Max since probably about 2003, 2004.
Terrific. I am a mediator also with the firm. I've been here with Upchurch Watson White and Max since 1999. I'm a member of the American Bar Association Dispute Resolution Section and the Palm Beach County Bar Mediation Committee. Also am fortunate to be a part of the American College of Civil Trial Mediators. And like Howard, travel the state mediating. And for those of you who are joining us, if you would just appreciate, there's a chat feature. There's an orange arrow that you can minimize your dashboard on if you look at the upper right hand corner. So you can use that orange arrow to minimize the dashboard, and you can send us questions, but we will not see those questions live as we're doing this webinar, but we will at the conclusion review those so we can be as targeted in our response as possible. Feel free to give us any question that pops up. Like I said, we will do our best to follow up afterwards. So today's topic, like we said, is about the effective mediation summary. You want to kind of introduce it for us, Howard?
Yes, today we're going to talk about crafting the effective mediation summary. Subtitle is Frequently Asked Questions, Consideration, Psychology, and Suggestions. On the frequently asked questions, it was interesting. The attendees submitted questions, some of them, in this case, many of them, prior to the webinar today, and we have a lot of questions we'll try to get to at the very end. So hopefully we'll be able to answer some of those. I think most of the questions will be answered as we go through the workshop, and we'll talk about those as we get to them. All right, next. As I indicated to Richard earlier, my background is in journalism, and Journalism 101, you're taught an algorithm that governs really every story you write or present. They're called the 5 W's, and actually there's also an H, which I've not included for purposes of this presentation. Why, who, what, when, where, and the H is how. Probably the most important for crafting the mediation summary are why, who, what, and when. So we'll be talking about those a good deal today, and those are all interrelated. One depends on the other. And when we sit down to craft a mediation summary, I think this is a very important thing for us to remember. Going to the next slide. Why? That's probably the most important of all. Why? What is our goal when we sit down to craft a mediation statement? And you see there, no single recipe bakes every cake. Now, the baking the cake metaphor is really probably an inappropriate metaphor for what we're talking about here today, but I've used it by design because I want to make a point. And the point is that crafting a mediation summary is not like baking a cake. You know, if we're baking a cake, you know, you look at a piece of paper that says 2 cups of flour, 1 cup of sugar, half teaspoon of baking powder, etc., and throw it in the oven, and what comes out is a cake. Well, mediation summaries are not quite that simplistic, although I think many attorneys approach it pretty much like that. Every mediation summary looks pretty much the same, and when I was a practicing attorney, that was true for me also. It was always the same framework. Always the same people got the summary, always pretty much the same content. What Richard and I would like to do today, instead of giving you a recipe to bake a mediation summary, we'd like to give you an algorithm for thinking about what goes into a summary, because our objectives will vary from case to case, always keeping in mind why, who, what, when, and where. Now, going to the next slide, why am I preparing a mediation summary? Of course, the first question is, do I need a summary at all? I think it would be the rare case when you do not. At a minimum, you want to prepare the mediator to help you with negotiations. And without a summary, you're asking a great deal of the mediator. You're asking them to come in cold turkey without any thought in advance and do the job. So at a minimum, that ought to be your goal in any summary. Help prepare the mediator to help you. How complex are the facts or issues? Of course, that has a great deal to do with why you're preparing a summary. Is it a bridge collapse case, a whiplash, medical malpractice case? And why you're preparing it, if it's a complex case, you know, the experience of your mediator in the area that you're mediating also is important. If your mediator is a mediator who's been doing med mal for years, you may not have to explain a lot of medical terms. Otherwise, you may have to explain some terms if you're talking about construction, for instance. So you have to understand why you're preparing it. One reason you prepare a mediation summary, as I see it, is to prepare the mediator to advocate your client's cause. Another reason, goal in preparing a summary, is self-education. I know we don't often think of this, but I always learned a great deal when I prepared the mediation summary.
If I could interject here,
Sure.
you know, I think that's a very good point, because you do, if you are like, you know, any conscientious lawyer would be, if you are gathering your thoughts, you may be accessing your file and seeing, you know, what happened last week and what happened 7 months ago. And as you go through that process, I think it is a logical tool that can serve two functions, you know, to get prepared for the mediation yourself, and certainly to, you know, involve the mediator in your preparation. I think that's a smart thing to do.
I always viewed it sort of as a dry run for trial preparation. Another reason for preparing a mediation summary may be to educate your client. So this raises a question we'll get to later. Who gets the summary? Do you send a copy to your client? We'll talk about that. There are some pros and cons on sending it to your client. Do you want to educate the opposing party? Well, again, you see how why interrelates with who. If you want to educate the opposing party, then it will change what goes into the mediation summary, and we'll say a little more about that later too. Your summary, do you want to create a framework for negotiation? Maybe you have a complex case and there's a hierarchy of issues that need to be addressed. Well, maybe you can spell out in the mediation summary what those issues are and the order in which you think it's going to be most advantageous to your client to approach them. Establish a template for settlement. I have seen some lawyers in complicated cases actually attach a proposed settlement agreement, not necessarily with all the terms filled in. For instance, there may be a dollar amount that's not filled in, and a few other things, but that can be very helpful in a complex case.
That's
right?
a very good point. I do think that if you have a complex potential outcome, let alone, you know, the complexity of the case itself, when we're talking about the merits and how it might be worked out through adjudication, but if the solution that might be, you know, the settlement agreement is complex or has complex implementation components, I do think it's really smart to try to start working on that, you know, proposed framework, you know, in advance, and sending that to the mediator is helpful. Sending that potentially to the other side is helpful.
Also, having it in your laptop so that if and when you settle the case at the end of the day, you do not have to invent the wheel from scratch.
And thinking about that in advance certainly makes it more likely you'll include key provisions, you know, that when you're in the moment, you may not have at the ready. So you may have a better agreement at the end of your mediation if you do that work in advance to kind of get down on paper the different things you're going to want to include when you're going to have a complex solution that you're trying to achieve. All
right, Richard is going to talk a little bit about who.
Yes, and you all can certainly see from the slides so far that who is really, I think, the key question before you can delve into what and why. It's a logical question, but Howard and I both, and I'm speaking for Howard based on my experience, I'm lumping him in with me. Sometimes your mediator will receive a summary that will look like something that wasn't thoughtfully prepared just for that recipient. Sometimes mediators are given information and the mediator might be saying, well, why do they need to include that? Why are they including that? And the who, we talk about summaries before mediation in this presentation. And we hope you've all gathered by now that it's not just a summary you send to the mediator. That's what we typically think of. But you can and should think about expanding your set of people who may ultimately be receiving it. We're going to go more in depth in the coming slides about that. But you really don't know, what to put in unless you know who the recipient will be. We're all familiar, I think, with that phrase, know your audience. So think about who your audience is, and you can send the same thing to everyone. You can send something different to someone else. And as we'll point out later, you can certainly carve out things that you want the mediator to retain in confidence. So just know who you're sending it to before you know what to put into it. Go ahead and advance us to the next slide. Most mediations will involve a summary that has been sent to the mediator only. Howard, you were saying something before we started to record about the times closer to the advent of court-ordered mediations in Florida where the courts might have been compelling a sharing of summaries to the other side. I do see that, from time to time, and that can serve a valuable function to kind of make sure everybody's getting on the same page if you're sharing it. But most of the time, mediation summaries are being sent to the mediator only. I do think it's safe and wise to point out that it's being submitted, with the protections of confidentiality and privilege to the mediator. I think, going to the point of whether you send it to opposing counsel, that is a tricky question because you have to be comfortable what you're disclosing to the other side. You might feel safer disclosing something to the neutral that you're asking him or her to keep in confidence than if you're actually submitting it to opposing counsel. I do think that it's wise to share it with your client in advance, but I'll say this now, and I think it's important to always remember. You as counselors and advocates have two different hats. When you're talking to the mediator or opposing counsel or the other parties, you are obviously wearing the advocate hat. That's sometimes 180 degrees from wearing the counselor hat. And I have seen mediations where plaintiffs or defendants can dig in somewhat after hearing an artful and compelling presentation by counsel during an opening session. Certainly the same impact can be seen if you send a summary that is laden with advocacy and is devoid of counseling. So if I had a friend when I was still litigating one time say that she would only send things to the client if they couched it in terms of, hey, look, this is my advocacy for you, and it's quite different than maybe what I would be sharing just with you as your counselor. And when you're hearing me talk to the other side advocating for you, understand that I'm your advocate then, because you don't want to make expectations management that much harder. So if you send it to your client, you need to let them know the difference between advocacy and the counsel you would give them in private. I do also think that some clients would prefer to know in advance what you're going to be telling the mediator. I don't think all lawyers think about that, but if you are going to be sending a summary, depending on the type of case, depending on the type of client you have, and this, is why you don't have one recipe to bake, all cakes. You need to give thought to having your client review it in advance, because you don't want to have something picked up through the course of the mediation, whether it's in the presence of the other side or maybe just in caucus with the mediator in the room. You don't want to have something picked up where it's then made apparent that there was something that wasn't stated in the way your client would have preferred it be stated. Sometimes things can be set forth in summaries that are incorrect. So it's just good, I think, good practice, given the type of client you have, to let the client take a look. It's harder to do. It slows things down, so it's not right in every case, but just don't not do it without thinking about whether it's going to be beneficial or helpful to you, the attorney, in this particular case you're talking about. And certainly different versions to different people is fair. So we can maybe move on to the next slide.
What information do I include in the summary? Well, of course, as Richard has already hinted at, it's directly dependent upon our goal and the intended recipients. Go on to the next slide. Anticipate. One of the cardinal rules of negotiation is that you do not want any surprises during negotiation. You probably want to avoid surprises unless they're very well thought about and intended for the other parties and the mediator. So the information that you put in needs to show that you have anticipated all the problems. Next, Kathy. Some considerations regarding the content. We're talking about the what component now of the algorithm. What do I put in the summary? Well, what if you have no intention of settling? You want to share only limited information with opposing counsel? Well, then you have to consider maybe withholding certain information from opposing counsel. Maybe this is a situation where you don't want to give opposing counsel a copy of your summary. Another consideration is, will the summary be read by the opposing party? Notice I underscored party there, not the opposing attorney, but the opposing party. One of the great advantages of mediation is that it gives us as attorneys the chance to talk for the first and only time to the opposing party. You know, there's to get past the attorney filter, as it were. So if you have an expectation that your opposing counsel will provide your summary to the other party, then that may well affect what you put in the summary. I have seen some summaries where the drafter of the summary has asked opposing counsel, please provide this a copy of this to your client, and we will provide a copy of yours to our client. That can be helpful. Should we consider sending a draft copy to our client? Richard's already talked about this, but there's a big caveat, of course, and that's client control and client expectations. If we aren't careful, we may create unrealistic expectations in our client. Richard's suggestion, I think, that we point out to the client that we're being advocates is important. But still, I think we have to be very cautious. If we've drafted a really strong advocacy mediation summary that we're going to send to the opposing party, I think we have to be very careful in whether we give that to our client, and if we do, what warnings we give with it. Why not substitute my motion for summary judgment, my suit report, or pleadings in the case? I will sometimes get a party's motion for summary judgment or suit report or pleadings in the case. I will tell you that pleadings in the case are not generally very helpful. By their very nature, they are a postcard. They are not a letter. So I don't find those very helpful. Motion for summary judgment, the problem with a motion for summary judgment in most cases is that they tend to be law issue specific, so that you don't tend to get the big picture. Sometimes a motion for summary judgment in an appellate mediation can be helpful, but I don't think motion for summary judgment is, in most cases, a substitute for a summary. They may be a good attachment for the summary. Suit report, I know that defense attorneys very frequently will plagiarize from their suit report when they draft their mediation summary. I did it myself for years. There's nothing wrong with that, but by merely sending your suit report, there are certain risks that go with that. And one of the risks is, remember, when you send a suit report to your client, you're telling them both the strengths and weaknesses of your case. And while that may work with a mediator, you certainly would not want to send that to your opposing counsel. All right, Richard?
Thank you. I think you can all tell now that Howard and I are coming at this topic primarily from the perspective of folks who spend a lot of time mediating civil trial matters. So a lot of our observations, are going to stem from the kinds of cases that we mediate. And what I would say about other things you might want to consider including, I would mark this down on a piece of paper and say, this is what I should include in every mediation summary to the mediator, and that is the other side's weaknesses. That kind of focuses the mediator's attention at the beginning on the things that might create leverage in your favor in the mediation, and that means potentially leverage in your favor that can be utilized during the caucuses with the other side. I do think sometimes too much is spent going over the history of someone or something, and that is helpful for the mediator to have as context for the dispute. But I think sometimes that overwhelms the illustration of what the weaknesses of the other side are. I think it's important for you to have an understanding of your weaknesses. You can't be a good advocate or, more importantly, counselor to your client if you don't appreciate your weaknesses. For the summary, you can certainly point out your weaknesses to the mediator, but you may miss an opportunity for the mediator to have in his or her mind from the outset, and maybe, you know, it'll always stay there front and center through the mediation itself. If you tell us their weaknesses, and that gives us something to be thinking about when we're in the other side, in the other side's caucus. So that's something that I think you should give a lot of attention to in preparing your summary. But it does help the mediator also from a non-substantive perspective to appreciate who's coming, what everybody's job is. You know, it's important for us to appreciate that, not only for planning purposes. Does your mediator have enough space in the room they're planning on using for you? But it's nice to know who the players are and what their roles are. And this third bullet point on this slide, it talks about, and I'm sorry, I'm near a road and you might hear some noise in the background. Hopefully it's not too loud for you, but I can't really go on mute in mid-sentence. This point here, enough detail to help the mediator effectively advocate my client's cause. Translated to their weaknesses. The other side's weaknesses, I think, and it may be more than that, but I wanted to start this slide by saying you gotta give thought to not having the mediator lose the other side's weaknesses in all the details that you provide. And you want to demonstrate an appreciation, perhaps, to the mediator of your command of the case. That may not be as important, though, as your demonstration to the other side through the opening session, through the back and forth of your caucuses, and through your counsel to your client, a demonstration of the mastery of the facts and law of the case. One point related to this that is related to the case's weaknesses, it can be very powerful, and this slide presentation is not focusing on what to do in the opening statement and what to do in the caucuses. However, think about the value potentially of pointing out your weaknesses and how you would defend them in the opening session, so you kind of get ahead of what the other side might spend a lot of time pointing out to your client and to the mediator. That subject, that subject can be talked about in another program, but it is related to this last bullet point about the mastery of the facts and law of the case. Less important in the summary than in the actual mediation itself. Do you want to go ahead and slip over to the next slide?
All right, more content. Of course, one thing you absolutely have to do in the mediation summary is to provide enough of the facts of the case so that the mediator and whoever the recipient is understands what the underlying facts are. But perhaps you ought to consider putting in, at least for the mediator, a general statement of your client's goals at mediation. This may be one you don't necessarily want to share with opposing counsel, but maybe in a separate summary, you could put this in for the mediator. In fact, we're not suggesting that you sit down and draft 2 or 3 separate mediation statements, one for the mediator, one for the opposing counsel, one for your client, etc. But you can use the same basic mediation summary and maybe add a paragraph or 2 for the mediator and the one that goes only to the mediator, and maybe add admonitions to your client, the one that goes to the client. So, you know, we're not talking about totally different mediation statements or summaries. But a general statement of your client's goals, I think, is very helpful for the mediator. Any obstacles to settlement or special problems. Sometimes there'll be a strong emotional obstacle to settlement, or some other, maybe a special insurance problem. You need to point those out for the mediator And if it's something that you and the opposing counsel have to wrestle with, maybe you want to lay that right out on the table for the other party. For the mediator, if you have client control problems, or if any of the parties have client control problems, it may well be that the opposing party is the one with client control problems, and you need to warn the mediator of that. I like to tell my clients when I have telephone conversations with them in advance of the mediation, please tell me where the landmines are. And I think that's one of the jobs of a well-drafted mediation summary. Where are the landmines? Insurance coverage or solvency problems. Certainly those need to be out on the table. Talk about the status of discovery or pleadings and their effect on negotiations. It may well be that there has been no discovery in the case. How's that going to affect the ability of the parties to settle? Sometimes judges will order a mediation prematurely, and the parties come to the mediation really with no hope of resolving it because there are key issues out there. Well, at least those ought to be disclosed, it seems to me, to the mediator. That doesn't mean a case can't be resolved at that stage. They often do get resolved, even when they've been ordered prematurely. But still, it helps the mediator to know that. Next.
So I've heard people say in the past, in advertising and other forms of communication, that you would like to try to have every word move the message. I think it's important to try to avoid things that might distract, important to avoid things that might be interesting but not really related to the task at hand. So as you are drafting your summary, I would have in the back of your mind the notion that every word should move the message. Sometimes it's important for the mediator to understand historical fact or procedure, but be thinking about whether or not it's important for the task at hand and the day of mediating. Whether or not these things will fall away in importance, and try to give the mediator, because you have limited time, and who knows, the mediator might have limited time to read things in advance of the mediation, and we've had some questions about timing and the like raised that we'll talk about, but you want to make sure that you're using best use of your written word and the time that you took to put it down on paper. And I want to move off the concept of paper and pick up on something Howard just said about the pre-mediation telephone conference. I think that a phone call in advance can serve every function that a well-crafted mediation summary can serve. Of course, it depends on your time and your availability and your opportunities to talk to your mediator, and your mediator's opportunities to answer the phone. But I think Howard and I both have, and whenever you set a mediation, your mediator will send you a confirmation letter that should set forth his or her preferences or requirements. I don't have any requirements. Howard doesn't have any requirements, but we obviously have preferences. And I think that's something that goes without saying. If your mediator expresses a preferred method or mode of or level of detail in communication, you don't want to ignore that. I know that our engagement letter, Howard, and yours probably is tailored similarly. Tells the attorneys that we would review anything they send in advance of the mediation, and that we recommend that summaries be exchanged with counsel, or you have the alternative option of sending it just to us, or if you send something to us and opposing counsel, you can include a confidential addendum just to the mediator, and we do make ourselves available for any pre-conference caucuses. Pre-caucus or pre-conference phone conversations, can let there be an exchange between the attorney and the mediator, so that we get oriented really quickly to what's important, and that is a good time to maybe let us know about the landmines that Howard touched on. But, you know, going back to additional content that you may want to include in your summary, you know, if you're sending it to the other side, you may want to attach not only that complex term sheet that we talked about earlier that can create the framework or architecture to negotiate and ultimately memorialize an agreement. You know, you may want to be submitting, if it's a different kind of case or a party or law firm or lawyer on the other side that you're not used to working with in the particular kind of case you're working on, include a copy of the general release, whatever the basic content of a release might be. You might want to think about sending that in advance. In the summary itself, you know, it's wise to talk about whether or not, if a complete agreement isn't possible, if there might be room for a partial settlement. You know, context of negotiation, has there been recent negotiation? That helps the mediator, I think, understand where everybody has been recently. And it's really important if where you've been recently is going to set the stage for the negotiations that you may avail yourselves of at the mediation itself. I think any new case law, any new development, any new court decision, you know, anything new that could impact potential for success at mediation, that could impact the other side's assessment and analysis, your side's assessment and analysis, that's good stuff, things that are recent. But again, I would point out, at a minimum, I think it's best for you to tell the mediator what the other side's weaknesses are, because that gives us some talking points that you may want us to have during each caucus. If you want to go ahead and flip to the next slide.
One of the questions that someone asked in the when they signed up for the webinar is what should I avoid? Well, a few things that occur to me that I see that I think are totally counterproductive. One is ad hominem attacks on parties or counsel. I know that sometimes you get to a mediation and the attorneys have been warning since they first met each other, and they hate each other, the parties hate each other, or both. You know, maybe you could point out in your summary that, well, there have been disagreements between counsel, or the other counsel is taking a position we regard as unreasonable. But as a rule, you know, ad hominem attacks, I think, are not helpful. If there's a real problem interrelationally with the parties or the attorneys, maybe catch the mediator out in the hall, but just before the mediation, and say, you know, we're going to have a real problem today because I and the other attorney don't get along. But in the summary, you know, for the most part, I would certainly avoid outright, you know, vituperative attacks on the other party. Over the top.
You're going to make me go get a dictionary, aren't you?
Over the top hyperbole, you know, exaggeration may be good. I'm not sure it's always even good at trial, but try to avoid misstatements of law or fact or hyperbole. Nothing is going to destroy your credibility more quickly, I think, at a mediation or at trial than a misstatement of fact or law. So many times I've gone from one caucus into the other and heard the people in room number 2 say before I can even open my mouth, you see what we've been putting up with. You see why we can't settle this case. He doesn't even understand the facts of the case, or she is totally misguided on what law applies. So you certainly want to avoid misstatements of fact or law, overly rigid declarations of positions and intentions. Never is a word that I think should be used sparingly, if ever, in a mediation summary or in negotiations. You don't want to nail your feet to the floor unnecessarily. Invective, you don't want to do. I know even if you send the summary only to the mediator, I'm not sure it paints a very good picture of your own personality to spend 2 or 3 paragraphs on a diatribe against the other party or the other attorney, or any statement designed to throw gasoline on the fire. Richard?
Yes, I think that's important stuff to point out. You know, we all leave a wake, like a boat leaves a wake in the water, in case the audio wasn't clear enough. We all have reputations. We're all building or tearing down our reputation in every interaction we have. And you all know life is about relationships. So you don't want to lose credibility. You don't want to look like you don't know the case. You don't want to look like you're creating problems. Don't say something if you don't know it to be true. All of these things, Howard and I have seen the problems that overreaching causes in a mediation. I'm not saying overreaching based on a review of the case, overreaching based on the merits, if you will. I'm saying things that might not be grounded in the case, and you don't want to have the mediator spend a half hour or an hour unwinding the problem you cause by saying things that show you're exaggerating or that show you don't know the case. So let's go ahead and flip up to the next slide. When do you send the summary? I'll tell you this. You can call me the day before the mediation and talk to me for 15 minutes, and that's good. You can send us, a mediation summary. Again, if we're just talking about the summary to the mediator, 3 or 4 days ahead of time, should be plenty of time for us to get it and read it. If your mediator has a preferred time set forth in his or her engagement letter, try to accommodate that if you can. If you're sending it to the other side, you want to send it a lot earlier than that, because assuming that your goal of sending it to the other side is to influence their analysis in a way that inures to the benefit of your client. If you're trying to get the other side to bake something into their analysis that's going to ultimately help in reach a resolution, you don't want to send it to them before it can, get cured and get good enough, get planted well enough in their analysis. It's kind of like the idea of sending something to your client to get authority. You want to get it early enough to them so that they can bake it into their process. It's like, when do you send a demand? You want to send a demand early enough so it can get baked into the other side's process. The spectrum is, sometimes we don't get anything, and that can be okay. Sometimes it's the day before, sometimes it's days before. But if it's something that's going to your client and you want them to give you feedback before the final version goes, obviously the sooner the better. If you want it to go to the other side so it gets into their analysis, the sooner the better. This question on this slide that we sometimes get about the, do we get involved, before the session? We've already touched on it. If you think there's an issue that needs to be worked out in advance, maybe something that goes to the logistics or who's attending, call us. And maybe we can set up a conference between counsel to work things out. But it's all about, it goes back to that first thing, who gets it, and what's your goal with it. Those two answers should inform your decision about when. Go to the next slide. This kind of encapsulates some of those things that that we've talked about, knowing what the mediator's requests are. Primacy and recency is an interesting is an interesting thing. I think everything's going to happen pretty close to the mediation, so I'm not sure if anything gets an advantage on the primacy or recency concept. And, Howard, you may have something to throw in on that there. But if anything needs to be done in advance, obviously the sooner the better would be the answer to the question of when.
Right. Next. Frequently asked questions. The first two we've already covered, I think, but the last one is an important one, I think. Should I tell the mediator in the summary what my absolutely best settlement number or position will be? Well, there are a lot of depends on that. Depends on how well you know and trust the mediator. It's never good in negotiation to nail your feet to the floor. What you think is your best position today may turn out not to be the best position as you get into negotiations and learn more about the case. But I think if you're going to do that, do it in general terms and not specific terms. That probably calls for as much judgment as anything in mediation summary. Richard, what do you think on that?
Well, I always tell people during a mediation that, you know, if you have an absolute, you know, that's your call. When you tell the mediator what that absolute is something you should give thought to, because there can be benefits to the process of mediating, even if you stop short of what your absolute is. At the end of the mediation, you know, it almost goes to a concept of the value of ultimatums in a mediation. I think lines in the sand and ultimatums should be resisted at all costs, and unless they are real and they have to be articulated. I don't know why you would have to articulate that in advance of the mediation to the mediator. I think that's something that can be, you know, developed. And you know, you might not want your mediator to have any particular thing in his or her head when they start about the potential for success. I think mediation is a process. We all know it. Our role as mediators in that process is ongoing, as are yours as an advocate and counselor. Your clients are engaged in the process throughout. So you know, and here's the deal. Howard and I have both started mediations where the lawyers tell us this case is not going to settle. And he and I have both, I'm sure, gotten to the point where these parties and these lawyers settle their case. So it's kind of like, what's the benefit of telling me early that it isn't going to get done, or what your absolute best will be? If it's really going to be the barrier, and it's not just a positioning kind of argumentative barrier or a posturing barrier, it's going to be more important. And it doesn't hurt for us to know in advance, but maybe you just kind of want to see how things evolve before you tell us where this realistic barrier is. There's no wrong way to do it. And these FAQs that we get, you know, have been things that, you know, we've gotten over the years, sometimes in the context of discussing mediation while we're at a mediation and discussing preferences with, you know, attorneys. Sometimes these are questions that have been raised with us when we've, you know, been presenting other programs. So that's where these FAQs come from, just so you know. So we can flip up to the next slide. And Howard, do you want to go from there?
Yes. One of my favorite New Yorker cartoons. I still don't have all the answers, but I'm beginning to ask the right questions. And we've thrown this in here for one reason. We want you to begin to address the algorithm. Whenever you sit down to write a mediation summary, it seems to me you should always sort of go through the mantra, the algorithm: why, who, what, when, where, and how. Okay, Kathy, let's go to the next one.
So we've talked about it. I think it's a good idea to tell the mediator it's confidential. If you send it to the other side and you send a little subsection or addendum to the mediator, make sure that the mediator sees that that addendum is marked confidential. People have asked if they should file mediation summaries with the court. That is, I interpret that question to be summaries in advance of the conference itself. I think you run the risk of running afoul of confidentiality rules. I do know that, of course, if you're in the habit of sending your motion for summary judgment to the mediator, then you've actually, and that's all you send, obviously you've sent something to the mediator and the court. But there are local rules that sometimes have to be followed, and wherever you are, I know we have folks from Alabama joining us and elsewhere, some local rules will specifically say don't do it. The local rules for the U.S. District Court, the Northern District of California, says specifically that you should send written statements to the mediator at least 7 days before the mediation. That's a when question. It goes on to say the mediator may request or accept additional confidential statements that are not shared with the other side. That goes to the issue of marking something separate as confidential. And it goes on to say these statements are not filed with the court. There's a similar local rule in the U.S. District Court for the District of Columbia, where you'll be admonished or warned, mediation statements shall not be filed with the court or served upon other parties to the lawsuit. So the question of who gets it and does the court get it, look at your local rules. Who bears the mediator's fee for review of mediation summaries? I don't know how all mediators do it. Mediators may say it in their engagement letter. That is part of the fee for services that are split between the parties. So I would say in my practice, it is part of what's split between the parties. Now, it can change a little bit. If somebody sends a ton and the other side, sends a letter, it could be that the mediator decides to flip a little bit more of the burden for that fee onto the party submitting the substantially larger amount. Howard, how do you address that?
Well, my engagement letter actually addresses that. As a rule, the mediator's fee for reviewing the mediation summaries, I allocate pro-ratably among the number of parties. Occasionally, though, when I got one of these, I guess within the last couple of years, in a huge construction case where one party literally sent a wagon load of documents as attachments or in addition to the mediation summary itself. I was called upon to make a discretionary decision there. How much of the review of those materials benefited the other party? So on rare, and it's very rare occasions, where there's just a really disproportionate submission, not of summaries, but of materials, I may charge more to the party submitting the wagon load of materials. But that is a rare situation where that happens.
And the last question here, do mediation summaries make a difference? I would say yes. Their impact, though, is going to be based on, and again, I'm assuming this is the question about does a summary to the mediator make a difference? I would say yes, because at a minimum, it helps us be prepared, and preparation is never a bad thing. And if you've helped prepare the mediator, you've also prepared yourself a little bit. So that second level of preparation, I think, can certainly assist everyone. Howard, we've got about 2 minutes to get through the slides if we want to have any time for some questions, and I need to make sure I'm able to share with everybody what our CLE information is. So let's move on to the next page.
Yes, survey common mistakes. Insurance coverage limitations, you need to cover those if you don't, if they're an issue in the case. Overemphasizing liability, losing sight of damages, vice versa. Failing to prioritize and define the issues. Failure to be concise, objective, and calm, or merely reciting a line item of discovery without any analysis. Or you have the secret weapon and you hide it in the haystack. You may or may not want to hide your secret weapon. Maybe you have a ton of surveillance film on the plaintiff that you want to use. When you divulge that, maybe you don't want to do that in the summary.
It's like in journalism, you're using the journalism algorithm, and also in journalism, there's the rule, don't bury the lead.
Yes. Okay, Richard, go to the next one.
Again, this word brief is up here for a reason. If you're going to give us the underlying facts, a brevity is probably sufficient. What's been going on recently is very relevant in many cases. This has already been touched on. Things that might be recent developments, context, and where we are in terms of settlement efforts. And I would say down here, assessment of respective strengths and weaknesses. Focus me on the other side's weaknesses. That's going to give me leverage that you might want me to have when we're in the other room, and creative solutions that are available. That's nice in advance, and that kind of is tied to the issue of getting some, if it's going to be complex or different or novel, get it out there in advance so the other side can start to envision the structure or architecture of what it is that might be possible at the mediation. So we'll go ahead and go to the next slide.
Obviously, you want to identify the parties and the representatives and counsel who will attend the mediation. Probably one omission I see very frequently is they will not identify the representatives who are going to attend. I can tell you from a mediator's perspective, it is nice to know before I walk into the mediation who's going to be present so I can call them by their name. So if you know who your representative is, I think that's something that you ought to probably put in there. Any sensitive issues that are going to affect resolution, prior future relationships of the parties. It may be the parties have an ongoing business relationship, and maybe that's something that needs to be preserved. And if so, maybe you need to let the mediator know that. Negotiating strategy, maybe suggested approaches you'd like the mediator to try. Right, Kathy?
We're going to try to go fast from here on in now. So again, persuasion, sales is a word that we don't always use. You're trying to persuade, have that front and center in your mind. And I know, Howard, you want to go ahead and share some parting thoughts.
Well, just the parting thought here is that, negotiation is persuasion, and we don't persuade people by intimidating, abusing, badgering, shouting, insulting, or degrading or attacking them. I sometimes am absolutely confounded when I hear attorneys who would never dream of badgering a jury set about to badger the other party during a negotiation. Persuasion, as Richard says, is the key. All right, Richard?
On the other side of persuasion is inflating expectations, so beware and be careful to balance it. Let's go to the next slide. And this is where I want to go ahead, and I think what we'll do is if we have time maybe for one question, Howard, we'll do it after this, but I want to go ahead and share the information that you see. Howard's email address is there. My email address is there. If you have a question or if you asked one when you registered and we did not answer it, feel free to reach out to us and email us. If you're a Florida attorney, please write down the Florida Bar course number for your CLE credit online. I'm going to read it to you. It's the number 1907292, N as in Nancy. Again, that's 1907292, and then the letter N. If you are in Alabama, you'll be getting an email from us subsequent. We do have offices in Florida and Alabama. That's why I pointed out Alabama attendees. You'll be getting an email following this that'll have some questions for you so that we can then report credit for you. Please also note down in your calendars on November 20th, we're going to have a webinar about mediating franchise disputes. And on December 11th, there'll be a mediator, there will be a mediation-focused webinar that'll be about negotiation tips, techniques, and the language of professionalism. So please also pay attention to your inbox on announcements and registration opportunities for these. Again, our email addresses are there. I want to thank Kathy Klasny, and then we're going to have maybe enough time for one question, Howard, but Kathy Klasny, our media manager, put all this together. Thank you for running it flawlessly, I think, and Howard, thank you for putting together the bulk of this program that I think has covered a very important topic. So we go ahead and maybe just hit one question if you can, Howard,
Sure.
if you have one of those that
One
stands out.
question is there any form you use for the preparation of the summary to ensure you've included all the important data? I would say that this webinar probably is as good a form as or checklist as you're going to have out there, particularly the last few slides. So use that, I would say. Richard?
That's it. I think we'll go ahead and close. This has been Crafting the Effective Mediation Summary, a workshop, and Howard and I are pleased to have been able to participate in this program brought to you by Upchurch Watson White Max Mediation Group and the University of Florida Levin College of Law Institute for Dispute Resolution. Thank you and have a great day.
Thank you.